Hi, CJ Fiorelli here with Beverly Hills Legal Services. Today we're going to talk about how to create your estate plan. First, a story. Joe was a potential client of mine, a busy doctor. He kept canceling his appointments, kept putting it off. I don't know. He said he wanted to create a trust for his two sons, Ben and Daniel. He never came in. Guess what? Now Ben and Daniel are coming into my office saying, CJ, what can we do? We're going through probate. And I said, sorry, Ben, Daniel, your dad never came in to do a trust. So now you are going through probate. They said, yeah, we know. We have to pay some lawyer like $80,000 because my dad left $1 million property here in the San Fernando Valley to us. And not only are we faced with $80,000 worth of lawyer's fees, but it looks like it'll be 2 to 3 years before we even get the asset. And Daniel needs the money. He's got a kidney problem. He's got to get a kidney transplant, and he needs to buy some coverage for that, extra coverage. I said, I'm sorry. I mean, your dad was a really nice guy, but he really didn't do anything to benefit the family by creating a trust. So let's talk simply. What is the difference between a trust and a will? A will is your key to probate, guaranteed probate, all right? If you only have a will, that means you can go through probate. You can go through the whole court process. You have to pay some lawyer about 7% of your entire asset portfolio. So let's just say you had a family home here in the San Fernando Valley. That's worth $1 million, not uncommon. That means 7% of that $1 million house, even if you haven't finished paying off the house, is based on the fair market value of the house. A judge is going to award your lawyer 7% of $1 million, which is about $70,000. Ugly. So what do you get with an estate plan? You get a revocable trust that avoids probate, a durable power of attorney, a pour-over will, and a certificate of trust, and then we fund the trust. Let's talk about a durable power of attorney first. That kicks in during your lifetime. Let's say you or your wife becomes incapacitated due to a stroke or dementia. Then the agent for your power of attorney can go to the bank, pay your bills, even perhaps make medical decisions for you. That depends on how you structure the durable power of attorney. Look, don't create an estate plan and leave out the durable power of attorney. This is important during your lifetime. You got to have the durable power of attorney. Now, your pour-over will, what's that? CJ, you said I shouldn't have a will because that goes through probate. This is different. In tandem with your revocable trust, the pour-over will is a stopgap measure. That means if you had the intent to place something into the trust, and you can use the Hegstead exemption if you have to go to probate court, it says that you had the intention of placing that property into the trust. Maybe you forgot to put it in the trust. Maybe you just didn't have time to transfer it. You passed away before you had time to transfer it. The courts, the probate court, will indicate in their minds that you had the intent to place that property into the trust, so it should avoid probate, all right? So the revocable trust, again, helps you to avoid probate. Oh, CJ, what if my son's on the deed? No, that's not going to help. You can still go through probate, even if your son's on the deed. Don't look for a shortcut. Do not look for a shortcut, okay? Now, the certificate of trust is critical when you go to administer the trust. If you have to go to the bank or you have to talk to your stocks and bonds company like Charles Schwab, they're going to ask for the certificate of trust. They might even need an EIN number, and we produce that for our clients. So the pour-over will, the revocable trust, the durable power of attorney, and the certificate of trust are all very critical documents. Now, how do you fund a trust? A trust just by itself with a beautiful binder and a lot of legal documents is nice, but it's like having a Mercedes without an engine. Unless you just want to look at the car, what good is it? So you have to fund the trust. That means you have to transfer your real estate into the trust by way of a deed. We actually go down to the county recorder's office here in Van Nuys most of the time and transfer your property, whether it's a family home or maybe you have passive income property like apartments. We transfer all that property into your trust, because if you don't, then the whole reason for creating the trust is down the toilet. Why'd you do it? If you don't transfer property into the trust, it is worthless. So look, those are the fundamentals. Now, one final thing. Some people say, hey, CJ, What is the difference between a revocable trust and an irrevocable trust? Well, as the names indicate, irrevocable means it's very difficult to change. You might even need a court order, and here's the irony. They call a revocable trust a living trust, but it really kicks in after both you and your spouse pass away. It's not really a living trust, it's a dying trust. The irrevocable trust is a living trust. That means you're actually transferring your property during your lifetime. It's dangerous because what if you submit some information to your children and say, hey, look, I just created an irrevocable trust. That means they're going to get your property now while you're alive. You lose control. You no longer technically own that property. Hey, but CJ, is that a great asset protection tool? Well, not really. I mean, asset protections means that you're protecting assets with an LLC or a corporation that you actually own. Here, you're giving up ownership and control of your assets. Yes, you are avoiding some estate tax issues for your higher net worth individuals, but be careful because the irrevocable trust gives all your power to your beneficiaries. I had one friend who created an irrevocable trust, and he got into an argument with his son, who was unfortunately using drugs, and the son tried to evict him from the family home. It was a huge mess, all right? But, I mean, ultimately, it just cost the doctor tons of money to just stay in his own house. So be very careful. If you want to create a revocable trust, is probably the best way. I can't give you legal advice on that, but think about the differences. One final thing, the stepped up basis in your property tax. Under Proposition 13, you used to be able to pass on your tax basis in your property to your loved ones. Example, you bought a house in 1980 for $200,000. That was your tax basis for property tax. Now it's worth $2 million. Under Prop 19, the only way you can pass on that favorable tax basis, that stepped up basis, is if one of those beneficiaries actually live in your house, in your domicile. So the Proposition 13 benefits have kind of gone away. All right? Think about what you're doing. And they say, oh, well, CJ, I'll just create an irrevocable trust and I'll preserve that stepped up basis. It may not be worth it. All right? Contact us at Beverly Hills Legal Services. We're going to help you create the trust properly. We use vetted documents, and we're going to create a trust. So far, in 30-some years, we have never had a contested trust, not once. So call us, 424-249-0059. That's a very quick analysis of the difference between probate and an estate plan. Get your estate plan now. Don't wait. Don't let what happened to Dan and Ben happen to your loved ones. All right? Call us today, 424-249-0059.